Hello viewers, I'm Advocate Kia Rawat. Today I'm going to talk about the oral and documentary evidence under Section 3 of Indian Evidence Act. So here I would like to tell you evidence means and includes number one, oral evidence. All statements which the courts permits or requires to be made before it by witnesses in relation to matters of fact under inquiry, such statements are called oral evidence. Second one is documentary evidence. All documents including electronic records produced for the inspection of the court, such documents are called documentary evidences. Now, oral evidence falls under section 59 and 60, whereas documentary evidence falls under section 61 to 90A of Indian Evidence Act. Here I would like to tell you about what is oral evidence. So, Section 59 contains two principles. Number one, all facts except the contents of documents or electronic records may be proved by oral evidence. Second, oral evidence must be direct rather than hearsay evidence. Hearsay evidence is like, suppose I have seen someone of doing something wrongful act. So here I'll get that information from someone else, like he will say me that someone has done this act. So but that is the hearsay evidence. Hearsay evidence is indirect evidence, that is not the direct evidence which you see yourself. So section 60 deals with what is direct. For example, in the case of seeing, hearing, perceiving and making opinions and grounds of opinions, the evidence must be given only by a person who has seen, heard, perceived or made the opinion. That is direct evidence. Direct evidence is, for example, eyewitness. Someone has seen someone committing the murder. So he is the direct witness in that particular case. And what is hearsay evidence? Hearsay evidence means, suppose A has seen B doing some crime. Now A is the direct evidence over here. What if A tells this to B and B then tells this further to C? That will be hearsay evidence. So the exception is that opinions of experts expressed in any treatise commonly offered for sale and the grounds on which such opinions are held may be proved by the production of such treatise. If the author is dead or cannot be found or has become incapable of giving evidence or cannot be called as a witness without an amount or delay or expense which the court regards as unreasonable. So this is what oral evidence is all about. Now, according to section 3, there are two types of evidences, namely oral evidence and documentary evidence, as I have already mentioned above. Now, oral is different from the verbal one. In case of Queen Empress versus Abdullah, 27 February 1885, Honorable Chief Justice of Allahabad W.C. Petram discussed the difference between the verbal and oral. Means words. It is not necessary that the words should be spoken. If the term used in the sections were oral, it might be that the statement must be conformed to words spoken by the mouth, but the meaning of verbal is something wider. So this is what oral evidence is all about. I hope you like my video. If you have any questions regarding what is oral and what is documentary evidence, do let me know and I'll clear all your doubts in my next video. See you super soon in my very next video. Till then, take care of yourself.